of Tennessee is now in session.
Thank you, Mr. Hivner. This is the January session of cases to be orally argued in the Tennessee Court of Criminal Appeals here in Nashville, the middle section. My name's Robert Wiedemeyer. I'm from Nashville. I live here in Nashville. My colleagues are on the panel are Robert L. Holloway Jr. from Columbia, Tennessee, and Timothy L. Easter from Williamson County, Tennessee. We're pleased to be here this afternoon. We would like to be in the courtroom handling cases the way we normally do, but we are grateful to the Administrative Office of the Courts and to our clerk, Jim Hivner, and his staff for working out the technology that makes it possible for us to continue during the pandemic to hear oral arguments on these cases and to get the cases decided and disposed of in a timely manner. We have read the briefs. We have not had a look at the record yet to any extent, but we have read the briefs and are familiar with your cases to that extent. We'll conduct court as close to normal as possible in that regard. I mean, each side has 20 minutes to argue. If the appellant wishes to reserve some rebuttal time, let me know before you begin your argument, and I'll assist in keeping up with how the time is utilized. And I think that's all the preliminary matters. Mr. Clerk, any preliminary matters that you're aware of?
No, Your Honor.
All right. If you would be good enough to call the next case on the docket, please.
State of Tennessee versus Corey Forrest.
All right. Mr. Colley, you ready?
Yes, sir. Good afternoon, judges. I'm John Colley of the Murray County Bar here on behalf of the appellant, Corey Forrest. I would like to reserve 5 minutes for rebuttal.
All right.
This is a rather unique set of facts. Back in April of 2014, Mr. Forrest was stopped on Highway 43 South within sight of the Lawrence County line. He had been followed to the county line by various members of the Columbia Police Department who had been looking for an opportunity to pull him over for a traffic violation. This wasn't some type of a traffic operation. It was actually it was a drug operation based on some facts which are largely uncontroverted. When Mr. Forrest was stopped in his Cadillac Escalade, the Escalade had been seen at an apartment complex near Columbia State Community College on successive days, 2 days, including the day that he was stopped. When his vehicle would be there for brief periods of time, traffic at the apartment complex picked up, and several vehicles were stopped leaving the apartment complex, and illegal narcotics were located in those vehicles. It's also uncontroverted that Mr. Forrest himself was never observed at the apartment complex. That's in the record. No actual drug transactions were ever observed, at least at this point. No drugs were ever located in the apartment that was under suspicion. That apartment was not Mr. Forrest's apartment. And there was no confidential informant involved in this set of facts. At least this is all that the Mr. Barber, the officer that stopped Mr. Forrest, this is what he knew at the time. So 15 to 20 miles from this apartment complex, as Mr. Forrest approaches the county line in his Escalade on 43, the speed drops down to 55, from 65 to 55, and then almost immediately to 50 for the intersection where the traffic stop occurred, which is near the small community of Summertown. As Mr. Barber, Officer Barber, follows Mr. Forrest about 3 car lengths behind him on this 4-lane road. And this is all on the video. He had no radar. So what he attempted to do was pace Mr. Forrest and pace him so that he would be in excess of the speed limit and there'd be a reason for a traffic stop. The police suspected that Mr. Forrest was delivering drugs to the apartment complex back in Columbia, and Officer Barber had been told to obtain a traffic stop by his superior. And so you'll see the speed signs drop down on 43 from 65 to 55 to 50 within a couple of 300 feet of each other. And then you'll see Mr. Forrest's brake lights light up, and then you'll see Officer Barber stop him. Mr. Forrest pulls over. And at this point, when the blue lights come on, Officer Barber testified he had no intention of writing Mr. Forrest a ticket for speeding. Just admits that on the record under oath. Had no intention of writing him a ticket. Instead, Trooper Kilpatrick is on the way to this traffic stop with his drug-sniffing canine. But what Mr. Barber does do is approach the vehicle, identifies himself, asks for driver's license, insurance, and registration. Mr. Forrest produces insurance and driver's license, which is valid, tells Mr. Barber that he's got a handgun carry permit and that the gun's under his seat. And then Mr. Barber tells him to sit tight, and he goes back to his vehicle to run the license. When he runs the license, he's told by his superior, well, we've already done that. Mr. Forrest is valid and cleared. They had done that while Mr. Forrest was being followed out of Columbia. They did that, as you'll hear, it's in the record, that's usual procedure when they're trying to get a stop is, since they didn't know the driver of the Escalade, they would have run the tag on the Escalade, learned the driver's identity, and then run that identity for a valid license and any outstanding warrants, all of which would have provided a reason to stop Mr. Forrest. But as Investigator Shannon told Mr. Barber, he's valid, cleared. So at that point, not intending to write him a ticket, never wrote him a ticket. We're just basically waiting around for Trooper Kilpatrick to get there with the dog at the Shell station near the county line. A couple of things that Officer Barber testified happened after the stop, which the state apparently relies upon for a prolonged detention for the drug dog to get there. Officer Barber testified that he saw several 20s in Mr. Forrest's wallet when Mr. Forrest was getting out his driver's license or insurance or whatever. Said he thought it was around $200, and that indicated to him that Mr. Forrest was suspicious of Mr. Forrest being a drug dealer. And the other thing that Officer Barber testified to was his sergeant told him that Mr. Forrest told the sergeant during the stop that Mr. Forrest said he had been coming from Buffalo Wild Wings in Spring Hill earlier. And Officer Barber testified he knew that was a lie because they had seen him come from the apartment complex near Columbia State. Of course, the officers admitted at trial that they had no idea where Mr. Forrest had been prior to his brief stop at the apartment complex, whether Buffalo Wild Wings or anywhere else. So it's clear that it wasn't necessarily a lie. At trial, Officer Barber added one more detail that he said he observed during the stop, and that's that Mr. Forrest was nervous, fidgety, and had labored breathing. Now, at the suppression hearing, when asked what he relied upon 3 times, sort of like Peter in the Garden of Gethsemane, he never, ever once mentioned anything about being fidgety, labored breathing, or nervous. But at trial, he threw that in there. In fact, at the suppression hearing, he was asked, is there anything else that you noticed that gave rise to your suspicion that he should be held there till the drug dog got there? And he said, no, there wasn't. So what we've got at this point, we've got an alleged citizen's arrest all right, 20 miles, 15 to 20 miles outside of the jurisdiction of this officer. So it's got to be a citizen's arrest for speeding, pacing this guy near the county line for speeding. We use our blue lights in violation of state statutes for a citizen's arrest, since private citizens are not allowed to use blue lights. And we're pulling him over, but I guess my question is going to be when the state gets up here. I don't get to ask a question, so I'll ask it this way. If the stop can't be prolonged past the mission of the original stop, what was Trooper Barber's mission, since he didn't intend to write a ticket? And the officers had already run this man's driver's license and he was valid and cleared. What exactly was Officer Barber's mission when he stopped Mr. Forrest? And so let's talk about the possibilities. Going to write him a ticket for speeding. And he testified when he stopped him, he had no intention of writing him a ticket. So that wasn't the mission. Well, he's going to check his driver's license and registration. Immediately got it and was told by his superiors, oh, we did that on your way down. He's valid and cleared. So what mission at that point is left? What is then the mission that we've got to accomplish before we let Mr. Forrest go on his way this night? And there's not one. Now, the standard for a private citizen to be able to make a citizen's arrest is probable cause. It's not reasonable suspicion. And our Supreme Court and this court have said so. And I cited those cases. Bellamy from 2004 in this court, and Johnson from the Supreme Court, a reported case in 1983. And so if the state's going to change horses after all the officers testified he was being stopped for a traffic violation, in which case the mission was accomplished before the stop was ever effectuated, since there was no ticket. We're going to change horses and say this was a stop for dealing drugs. Where is the probable cause for that? Where is the proof that Mr. Forrest was dealing drugs at the apartment? And if he was, and they had probable cause, why did they need a traffic stop? What they had no one that ever saw a drug transaction. They apparently had no information that Mr. Forrest was the drug dealer, other than his Escalade showing up on 2 successive days, activity picked up after he left or after he was there. And that's really it. And I don't know that anything even approaches probable cause based on those facts and what Officer Barber knew. There's not any way that an arrest warrant would have stood up based on those facts. And especially in light of what he also knew, that the apartment under suspicion was not the defendant's apartment, that no drugs were located ever in the suspected apartment, that there was no CI who identified Mr. Forrest, that no actual transactions had been observed. And of course, Mr. Forrest himself had not been observed. The only way they identified him was to run his tag after he left. And that was all to see if there was some way to pull him over for a bad tag, bad driver's license, or outstanding warrants. So I don't know that this court has ever had a set of facts like this. I'd be shocked if they had. But this idea that we've got probable cause for either speeding or a drug arrest based on the facts at the time of this blue light's coming on, the appellant would submit, simply doesn't add up. If there are no further questions,
I have one. Did the trial court discuss the citizen's arrest aspect of your defense?
Yes, Judge, the trial court judge did do that. And the state, the district attorney who was working this case then, that was the horse that they traveled under. And the appellant concedes that under certain facts, there's cases out of this court where that stands up. But the standard is a little stringent. It's probable cause. And again, I don't know. I've seen cases where citizens' arrests have been made for speeding and for drunk driving. But those officers went ahead as private citizens and made arrests. There's not any where a citizen's arrest has occurred, where the officer acting as a private citizen had no intention of making an arrest for the crime that he was being stopped for, or even writing a ticket. And so I don't know that private citizens can make pretextual arrests, which everyone admits from the get-go. That's what this was. The trial judge said this was the most extreme case of a pretextual arrest he'd ever seen. And
it's unusual in a case like this. The officer would testify, I never had any intention of writing him a speeding ticket. I think that's the fact here that makes this so unique. Maybe what the trial judge was talking about. But it's been a minute, Mr. Colley, since I've looked at citizens' arrest authority in Tennessee. Can a citizen make an arrest if they have probable cause for any offense that they observe? Something as dangerous as a drug transaction? Can they still make an arrest if they have the backbone to do that?
Yes, sir, I believe they can. And the cases, especially the Supreme Court cases, say that they do so at their own risk. They could do that in this case. Your Honor would have to find, along with your other judges, that at that point, when he hit the blue lights to arrest him for this drug offense, that he had probable cause to do so, that he had probable cause to arrest Mr. Forrest for this drug offense.
And you don't think, based upon what he had observed back in Columbia at the apartment complex, creates probable cause?
No, sir, I don't. And obviously they didn't either, or they would have arrested him way before they paced him going 5 miles over the speed limit. He was told, I guess it's 4 or 5 times in the record, that he was instructed to find a traffic violation. So
if we were here and this stop had occurred within moments of your client leaving, then you wouldn't have an argument? If let's assume the officer is outside of his jurisdiction and he's acting in the role of a citizen, would he, your argument is because it took him so long to stop him? Well,
no, that's one problem. That's one problem that indicates to me that no one involved in this episode believed they had probable cause to arrest him for a drug offense. And otherwise, they would have not been looking for a traffic violation. And everybody that testified, all the officers that testified, 1, 2, 3, or 4, all testified that they had to find a traffic violation on him. Now, your honors may rule differently. You may look at what they knew, as it appears in the record, and conclude that they had probable cause to arrest him for a drug violation. But that's not what happened. And the officer never testified that he arrested him for a drug violation. The officer testified at trial and in the suppression hearing, I stopped him for speeding. And I was going to, it was pretextual, but that's what I stopped him for because I wanted to get the drug dog on there. And so I think a citizen could, but the standard is probable cause, and there wasn't probable cause based on what Officer Barber knew to arrest this man for possession of narcotics with intent to resale. And if there are no further questions, I will yield to my adversary and reserve whatever's left over.
All right. Thank you, Counselor. You still have your rebuttal time, and we're ready for the argument from the state. General Watkins, good afternoon.
Good afternoon, Your Honor. May it please the court. Austin Watkins here, appearing on behalf of the state of Tennessee. Your Honors, in this case, the trial court properly denied the motion to suppress the evidence from the traffic stop because Officer Barber had probable cause to stop Mr. Forrest for speeding, and the stop was not unreasonably prolonged by his use of a drug-sniffing dog to detect narcotics in this case. And Your Honors, if you direct me to any specific questions you have, I'm happy to address what would be of most interest to the court. Otherwise, I'll just kind of run through the probable cause with regard to speeding, and then some of the kind of nuances that Mr. Colley brought up. But
you agree that this officer was acting in the capacity of a citizen? You agree with that?
Your Honor, yes and no, and here's why. In the sense, from a constitutional standpoint, he was acting as a state actor. So regardless of whether under statutory law he was within his jurisdiction or outside it, Suppression is not a remedy for Mr. Forrest in this case, even if under Tennessee law, this officer was outside of his jurisdiction, acting as a private citizen. Does that kind of make sense? So he was still acting as a state actor, as the state's position, for constitutional purposes of the validity of the traffic stop. However, he was well within the county outside of his municipal jurisdiction, and the case law indicates that in Tennessee, that exceeds the statutory authority of the police officer so that he is then acting as a private citizen. The problem is that just doesn't help Mr. Forrest in this case. We cited the State versus Carter case from 2016, which is an unpublished opinion from this court. But in there, it clearly states that even assuming that an officer is acting beyond his statutory jurisdiction, a municipal officer, it doesn't affect the constitutional validity of the traffic stop. You still use the Fourth Amendment analysis for these purposes. And so here, Your Honors, as we've kind of pointed out, there was probable cause for speeding to justify the stop. And then there was also reasonable suspicion of drug activity for them to justify the stop. And the officer admitted very candidly, this was a pretextual stop. The purpose was to find a traffic violation basis to justify the stop. But the officer also testified that he believed he had reasonable suspicion to stop him as soon as he left the apartment, but also wanted that secondary justification as well. And Mr. Forrest they allowed him to drive many miles before they actually ended up feeling comfortable making that stop. But the case law.
Are you saying then a law enforcement person has some sort of extra level of protection on acting as a citizen when they pull somebody over for some infraction of the law? And that extra protection is they can either call it reasonable suspicion or probable cause, because I'm a police officer 4 counties over. Is that what you're saying?
Not that there's an extra level of protection, but from a remedy standpoint, when an agent of the state stops someone for constitutional purposes, they're acting as a state actor. And if they're acting as a private citizen, then Mr. Forrest has no recourse to the suppression remedy. And that's what he's got to have here to suppress the evidence. So whether from a state law perspective, right, an officer's jurisdiction is determined by statute in Tennessee, regardless of whether under Tennessee law the officer was acting as a private citizen or as within his jurisdiction, as an under the color of law as a law enforcement officer, for constitutional purposes, for Mr. Forrest to be able to get suppression as a remedy, it does not matter. It does not matter what the state law point is, because if it's just a citizen's arrest, then there's no state action for which to suppress. And so if he is acting as a state actor and suppression would apply, there is probable cause for the speeding violation, and there's also reasonable suspicion for the drug activity. And either one of those, for a constitutional basis, is adequate to justify the stop.
You're saying that every citizen that stops someone is a state actor?
For constitutional purposes, that would be the state's position, Your Honor. Now the recourse would be, and that's why in the case law, it says that officers who are acting outside of their statutory authority do so at their own peril. That may mean that they may be civilly liable to the defendant for acting without, jurisdiction as a law enforcement officer. So that would be their remedy if there's essentially some type of tort committed against them by another private citizen. But for purposes of them being a state actor just enforcing the laws, Your Honor, the state's position is that whether they're acting within their jurisdiction or not, relevant for a constitutional purpose. And so again, we cited the State versus Carter case, which doesn't say it as is in the most expounded way that I said it, but it does say whether an officer is acting outside of their statutory jurisdiction is not a suppression issue. So for Mr. Forrest here, that his best argument is that possibly somehow, maybe the stop was prolonged, where Mr. Forrest had to wait for 9 minutes, until this trooper came in with the drug dog. But Your Honors, the Rodriguez case from the Supreme Court that Mr. Forrest relies on, it's very distinguishable here because the Supreme Court says yes, it is a Fourth Amendment violation for an officer to add time to a traffic stop in order to conduct a drug investigation, but that's only if there's not an independent basis to justify that prolongation of the stop. And we have that here. There was reasonable suspicion before the traffic stop, and then additional facts came in through the officer's effectuation of the traffic stop that further lended reasonable suspicion to the idea that Mr. Forrest, possessed drugs. And so,
let me make sure I understand the state's position. State's position is that they observed this Escalade at a place where there had been drug activity. They thought they had probable cause at that time to pull him over. But instead of doing so, they let a Columbia police officer follow him 17, 15 miles, however far it is, until he gets almost to the Lawrence County line, at which point he decided he's going to make a pretextual stop so he can check to see if he can get the drug dog down there for drugs. That's basically what the state's saying.
that basically is, Your Honor. Yes, sir.
Okay.
There had been a multi-day stakeout of this apartment. It's a task force, essentially, I believe. I don't remember what all agencies are involved, but there's multiple officers have been watching this apartment. They've got reported drug activity at a specific apartment in an apartment complex. They note over their multi-day observation that corresponding with Mr. Forrest's vehicle arrival at this apartment complex, there's an increase in the foot traffic to the apartment. And they had stopped.
I think we get all of that, Mr. Watkins. It's why did they wait till they were almost out of the county to make the stop? And I don't know, maybe the record will bear out, but I would think the officer with the drug dog was coming from someplace up close to the apartment complex where the stop should or could have been made initially. So what's the explanation?
Your Honor,
is that important?
Well, no, it's not, Your Honor, but the record is not particularly clear on it. Officer Barber says, I thought I could have stopped him, but I also was ordered to find a traffic stop. And that's not uncommon, Your Honors, for law enforcement officers to want a secondary basis to justify their stop under probable cause, a higher standard than reasonable suspicion. So if it's easier for an officer to go, he was speeding, so I pulled him over, rather than risk that on judicial review, well, I didn't quite have probable cause, or I didn't have reasonable suspicion, even though the facts to me would indicate, whatever drug dealing activity, a court might see it differently. So he's just trying to be careful and say, if I can get two bases to stop someone, then I'm going to do that. And that was kind of, I think, what his supervisor told him to do. But the officer thought he could have stopped him earlier, chose to find a traffic violation. And as Mr. Forrest has pointed out, this officer didn't have a radar equipped. And I think the officer explained that his understanding from his training was that there was a 3 to 4 mile an hour, rate of error. So he may have been trying to get within a 10 mile an hour gap so that he knew he definitely had this defendant for speeding when he pulled him over. But Your Honors, it doesn't matter because federal law and state law is clear in Wren versus United States, and in this Supreme Court, the Tennessee Supreme Court, State versus Vineyard, pretextual stops are completely legal. I mean, it does not matter that, an officer has probable cause or reasonable suspicion and wants to take a safer course of action and wait for a traffic stop to also further support the stop. I mean, we see that in case law frequently, Your Honor. So there's no.
So he was ordered to stop this guy for a traffic offense. Did they tell him to stop him before he got out of Murray County, or did that come up?
Your Honor, I don't recall.
There's a lot of things about the case that smell the way it was handled, and I agree with Judge Easter. I mean, if they had probable cause to stop him for a traffic offense, for a drug offense, stop him. They apparently thought they didn't, or they were worried about having probable cause to stop him. So they wait, and they come up with this pretextual stop that he was speeding right before he left the county. Now, maybe he was, maybe what. We got a video, so I guess we'll get a chance to look at it. But, there's a lot of things about the case that smell bad to me.
Your Honor, I understand that. And the trial court felt similarly that when it commented that this was an extreme pretextual stop. But, Your Honor, the state's confident if you look at every line of attack on the validity of the stop, the case law supports everything that happened here. Just because an officer has probable cause or reasonable suspicion to make an arrest, the officer doesn't have to do it immediately. And so, it would have been simpler if they had stopped him as soon as possible. But, it is possible that the stop for, a drug offense would be reasonable suspicion rather than probable cause. In this case, on that basis, maybe a little bit of a wobbler. Was it probable cause to stop Mr. Forrest based on the observation at the apartment? Or was it easier for them to go ahead, have a guaranteed, justifiable basis to stop him for a traffic violation, and then they had the drug dog en route so that the stop wasn't, drawn out too long? It was basically a 9-minute process from him being pulled over until the drug sniff happened. And so I think on paper it sounds a lot more egregious than it is, but Your Honors, I think on the whole, this was pretty consistent and solid police work, other than this question of whether the municipal officer should have stopped him, within his jurisdiction or outside of jurisdiction. But from his jurisdiction, from a constitutional standpoint, there's just no problem in the basis for the stop. Even if the officer was acting outside of his jurisdiction, suppression is not a remedy for him acting outside of that jurisdiction. And as far as prolonging the stop goes, to bring in that drug dog a couple minutes later, the Rodriguez case is clear that that is only a problem from a Fourth Amendment standpoint if there's no basis to support the drug sniff at all. If it's just kind of a speculative drug sniff on top of a routine traffic stop. And that's not what we had here. We had a justification for the traffic stop. We also had reasonable suspicion, if not probable cause, for the drug offense as well. And so
what reasonable suspicion did the city officer develop between the time he started following the appellant and the time he stopped him? What reasonable suspicion did he develop that the drug transaction was taking place?
Your Honor, the additional facts would have been not while he was following the defendant, but during the actual stop, after the stop had commenced. So he's got this information that he knows from the other officers who were part of the stakeout, and he can use that to justify his stop. Then during the course of the stop, he sees the defendant carrying a large amount of cash in small denominations. He notices the defendant acting nervous.
You can't use those facts, can you? Because those all developed, as you say, after the stop. So you can't use those facts to develop probable cause for a stop, then, can you?
No, sir, not probable cause for the stop. That would be additional facts to support the justification of the drug sniffing dog. That would be at the back end of the stop. But
so a man in a Cadillac Escalade had $200 in his billfold, and that's your additional facts to justify bringing the dog?
And that he was acting unusually nervous, according to the officer, and that he was dishonest about his immediate place of departure before he was pulled over.
Is that proven? I thought the way I understood the record, they don't know where he was before he went to the apartment.
No, they know that he came from the apartment when he was pulled over. And they said, "Where are you coming from?" And he said, "Well, I was coming from, Buffalo Wild Wings." So he may have been at Buffalo Wild Wings before the apartment, but he didn't tell them, "Oh, I just left someone's apartment." That was what the officers construed as being what they considered to be a lie. So he was at least concealing the fact that he had come from the apartment, not necessarily that he had not been to the restaurant, which there's just no proof of in the record one way or the other. So the state's position, just to clarify, is that there would have been probable cause for speeding. There arguably, based on the facts from the drug stakeout, probable cause as well for the drug offense, but at least was reasonable suspicion for the drug offense as well. And either of those was sufficient to pull Mr. Forrest over in this case. And the fact that he was acting outside of his jurisdiction, Your Honors, is kind of essentially a red herring. It has no constitutional relevance for this case, because Mr. Forrest has to have access to the constitutional suppression remedy to get rid of this evidence in his trial. And that is, regardless of whether the police officer was acting as a private citizen outside of his jurisdiction, he was acting as a state actor for purposes of the Fourth Amendment, for the constitutional, state and federal constitutional parts of this. So, if there are any further questions, Your Honor, I'm happy to address those. But
General, I've got a question that's probably it may or may not be very important, but I'm just curious about this idea that defense counsel mentioned about these blue lights. You've got this police officer who is driving along initially within his jurisdiction. Then he goes outside his jurisdiction and he becomes a citizen for purposes. So he's going to make a citizen's arrest a stop. And the way he gets the defendant stopped is by turning on blue lights. And the way what I understood defense counsel to say is that's illegal. I mean, I don't know that this has anything to do with the merits of this or not, but I'm just curious. I mean, if you're a citizen driving along in your car and somebody goes by at 90 miles an hour and you think that's dangerous to my community, I'm going to somehow catch up with them and make a citizen's arrest. I always think of Andy, and Mayberry.
Gomer, Powell,
Yeah.
Gomer issued a citizen's arrest for Deputy Fife.
There you go. Yeah, Barney.
Yeah,
So,
Barney.
but you're, I can't imagine any way that I could, if I'm the citizen, I don't know how I would get that person stopped. And, maybe this has nothing to do with it, but defense counsel said in his brief and today in oral argument, so this citizen who also happens to be a police officer, but now he's acting as a citizen, he gets this defendant stopped by using the blue lights. And does that have anything to do with anything?
It has anything to do with something, but not to this case, Your Honor. I haven't looked at those statutes closely with regard to this because it doesn't affect the state's position. I think Mr. Forrest's counsel is correct that essentially blue lights are limited to law enforcement officers acting within their capacity. But again, I mean, whether he shouldn't have been using blue lights or should have, whether he was outside of statutory jurisdiction or within it, if he was acting as a private citizen, Mr. Forrest can't suppress the conduct of a private citizen. He can only suppress the conduct of a state actor. So he's just stuck here. It doesn't help him for any laws that were broken here. Now, that is when you look at the state case law, private citizens, law enforcement officers acting outside of their jurisdiction. For example, in the Martinez case that we cited in our brief, I think both parties may have. Speeding is one of those things that officers can do. And so you're right, Judge Wiedemeyer. I don't know normally how they affect that stop without the blue lights if they're acting off duty. So that issue doesn't really come up. Now, it may be a separate basis for prosecution of this officer for illegally using blue lights, or somehow it might be relevant to a civil suit. But for suppression purposes for Mr. Forrest's drug offense, that evidence was still admissible at his trial. Like, his stop was still legitimate under the Constitution, regardless of whether he was authorized to use his blue lights, whether he was authorized to be acting under the color of law as a Columbia police officer when he made the stop. So, this happens more often than I think sometimes we run into, where officers be working as a team, or they aren't really paying attention to where their jurisdiction stops and they'll stray outside of it. And so the reality, though, is when you look at the facts, the officer here had adequate justification to stop Mr. Forrest. And for constitutional purposes, that's really all that this court has to be concerned with. And then that's where the at his own peril language comes from in the case law with regard to whether there's some other remedy that might exist out there, regarding the officer's conduct for a state law perspective. All right. Well, if there's no further questions, Your Honor, that is the state's position. And I appreciate the court's questions.
All right. Thank you, General Watkins. Rebuttal time.
Thank you, Judge. First of all, we need to quit with all the multi-day stakeout. It was 2 days. 2 days, including the day this all happened. So we can quit saying multi-day like this is the French Connection or some huge Starsky and Hutch episode. It's 2 days. And so this is the second day when this happens. For some reason, every single rule or law that Officer Barber broke somehow strengthens, according to the state, this stop and this search. Every single thing, whether it was a statute, whether it was him pacing somebody with absolutely no training in pacing, stopping this man for 60 and a 55 when he admits there's a 4 to 5 mile per hour margin of error. A quarter mile, according to Judge Jones, a quarter mile from the county line with the county line sign in view. But this all somehow, according to the state's theory, strengthens the state's position, and Mr. Forrest just doesn't have any remedy. This thing doesn't just smell, this thing stinks. And it stinks from start to finish. That everybody that testified literally conceded they had to get a traffic violation. And they're running out of room. There is no proof in the record about what was said back and forth because these drug agents all use cell phones. They don't use radio traffic, so that we can't talk about it in the Court of Criminal Appeals. And so what we've got this guy. He's now a private citizen, but he's still using his blue lights. He's a private citizen, so there's no Fourth Amendment violation, according to the state. I want to see the case where the Wren approval of pretextual stops applies to citizens as opposed to officers. I haven't seen the case where Wren applies to this fact scenario where we've got a citizen making a private arrest. I would submit that an officer masquerading as a citizen because he doesn't care whether he has jurisdiction or not is a Fourth Amendment violation. And this is so far beyond what is acceptable or should be acceptable for police officers that I think this court has no recourse but to throw this mess out.
All right. Thank you, Mr. Colley, as usual. Oh, question?
I want to say one thing, and this is probably not directly related to, well, it's related to the facts of this case, but not to the issue. But here, this is a 7-year-old case. 4 or 5 years ago, we had it before our court on a certified question. We could have simply remanded it back to the trial court for redrafting of the certified question if we didn't think it was adequate, and we could have had this case over years ago. Instead, we found the certification not good. Send it back. Mr. Colley's then has to go through a post-conviction relief hearing, be found ineffective for drafting the certified question, and then we come back up and we do it on a bench trial. And to me, it is a wasteful procedure. Either the legislature or the Supreme Court needs to change it, give us the authority to send it back and have the certified question redrafted. And I just wanted to put that on the record of this hearing.
You're preaching to the choir.
All right. Thank you, both attorneys. Excellent briefs, good arguments. I think that's it for today's docket. We'll take up some more cases tomorrow, and so we'll be in recess until tomorrow morning.
This honorable court is adjourned for today.